Hey, good morning. How you doing? This is Will Farrell of Fed Employees Fight EEO Abuses. And our primary channel is over on YouTube. I'm sorry, over on Facebook, our communication session. We support each other. We empower each other. We share information. Hey, we encourage each other, let each other know that we're not alone in this struggle. And believe me, it is a struggle. Hey, I wanted to take a minute to read over some of one of my complaints. Another one of my complaints. This one will be on complaint number 8. It was an 18 claim complaint, which would seem like a lot, but is actually relative to the level of continued retaliation, harassment, and abuse that they just levied on me, man. It was horrible. And now when it's time to, of course, seek some justice, they don't want to pay. The system, well, let me read this to you and tell me what you think about the system. So I'm at the reconsideration phase. Reconsideration is not a right, or shall we say, you have to request it, and it's based on very strict criteria. It means that I've been dumped on my initial phase of my EEO rule judgment. Went through the appeal, got dunked again, and now my options are reconsideration or head over into circuit court. I'm okay with circuit court. I'm going to learn as much as I can learn, and I'll probably have to hire a lawyer, but up until date, I've been pro se. Item J. The AJA decision involved a clearly erroneous interpretation of material fact and or EEOC compliance manual section 8.2D3 1998 and EEO MD 110 and Chapter 5 at 3 August 5th, 2015 for claim number 8 when she improperly ruled or failed to rule on, the claim says, on June 15th, 2017, immediately after he raised concerns regarding harassment, his supervisor conducted a mid-year performance review without having measurable and quantified metrics for success established in the FY 2017 standards. First thing I want to show you is that the very specific requirements are right there in the first sentence that you have to put in your appeal. You have to show that the AJ decision involved a clearly erroneous interpretation of material fact or law. What I inserted was the law that she clearly misinterpreted. Okay? And the second part is that it was you have to show that their actions, greatly impact the agency's policies, blah, 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 blah. I rarely, in all the hundreds of cases I read, I rarely see anybody argue on the policies. But I try at the end to demonstrate that as well. I'll continue. So, for this claim number 8 on the reconsideration, it says, first, she improperly misinterpreted, reinterpreted, changed, and truncated the original complaint as cited in ROI and August 9, 2007 acceptance of complaints of discrimination. William Farrell agency complaint number blah, 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 which stated, now listen to the difference. On June 15, 2017, your supervisor conducted a mid-year performance review with you without having measurable and quantifiable metrics for success established in your FY 2017 standards that you deemed collusive and intimidating. Immediately after you raised your concerns regarding harassment, did you hear that? Did you hear the difference? I'll continue. It was improper to truncate and eliminate the portion of the complaint that stated you deemed collusive and intimidating immediately after you raised your concerns regarding harassment. I ask you, why would the judge cut that off? Why would they chop that off? Anyway, I'll keep going. The AJ's reinterpretation action changed the entire focus and criticality of the claim. and has the effect of mitigating, concealing, or masking the focal point of the principles of harassment, retaliation, and temporal proximity, which is an unmistakable nexus indicating retaliation. See Honstad versus Worcester Foundation. It's a court case you put in there, and you always want to cite the court cases that has the precedents that you're arguing. Trust me, you can be. They cheat. Well, as you see, the judge cheated, so I'll just loosely use that term. They cheat you regardless, but if you don't meet certain criteria, my study indicates you have no shot at justice. I'll continue. The AJ improperly ruled despite the record established that the allegations happened in close proximity to the complainant's June 14, 2017 protected activity with Supervisor 2 and in a mosaic or stair-step of reprisals and in close proximity to other protected activity, including EEO, within 20 hours, not weeks and months, nor years. See Miller versus Fairchild Industries and Devereaux versus United States Postal Service, inferring that harassment by supervisors intensified shortly after plaintiff filed an internal complaint. See Quiles versus Henderson. The June 14, 2007 protected practice further support the nexus of temporal proximity to protected activities and reprisals, but also a claim of a persistent pattern of alleged harassing conduct, where each instance by itself may seem relatively trivial or isolated, but considered together may allow a complainant to prove a hostile work environment. That's in Complainant versus United States Postal Service and Complainant versus Department of Navy. The AJ's non-decision on claim number 8 improperly failed to include, weigh, or rule on the merits and components of retaliation as defined by EEOC Manual Section 82-2D3 and Passer versus American Chemical Corps and Hashimoto versus Dalton to the harm and the detriment of the complainant. A materially adverse action for purposes of a retaliation claim is not the same as an adverse employment action required to bring a discrimination claim. Rather, it is an action that could well dissuade a reasonable worker from making or supporting a charge of discrimination. See Burlington Northern Santa Fe versus White. See also Steele versus Schaefer. And her non-ruling or inaction blocked or obstructed the court's ability to determine if it is plausible that a person in a plaintiff's position threatened with aggregation or collection of allegations would be dissuaded from engaging in protected activity. See Gordon versus U.S. Capitol Police. And the AJ improperly neglected to draw all justifiable inferences in the non-moving party's favor. See Aguado versus Department of Veterans Affairs and 29 CFR 1614.405A. In the preamble to 1614 regulations issued on July 12, 1999, the Commission advised that fragmentation of EEO complaints was a serious problem in the federal sector, and that harassment/hostile work environment claims are particularly susceptible. See Meany versus Department of Treasury, Drake versus Department of Air Force. Equal Employment Opportunity Management Directive, CRF 29 CRF Part 1614 EEO or EEO MD 110, Chapter 5 at 3, August 5th, 2015. See how I'm stating the laws that she violated or seriously misinterpreted? You got to be specific. They'll work hard to disregard it. I'm going to chuckle to see if they disregard this, and if so, how, what language. But it doesn't matter. I'm going straight to circuit court. I'm going to blast them in circuit court. Collected mostly all the discovery that I can collect or need to collect. They're toast. If justice at all is to be gained, they're toast. A claim refers to assertion of an unlawful employment practice for which, if proven, there is a remedy under the federal employment status. Fragmentation often results from a failure to distinguish between the claim the complainant is raising and evidence that's factual information she is offering in support of that claim. Judge fragmented my case. When each piece of factual evidence, usually consisting of a single incident, is identified as separate and distinct legal claim, it ignores the complainant's real underlying issue of a pattern of undergoing discrimination. For complainants, fragmented processing can compromise their ability to present an integrated and coherent claim. The fragmentation of EEO claims must be prevented at all levels of the complaint process. Complainants, oh, by the way, there's references to court cases. I'm just speeding up, not saying it. Complainant's complaint and its attachments unmistakably rise a claim that he was harassed by management and subjected to a hostile work environment. By the way, again, all of that comes straight out of the manual. I didn't make that up. If the AJ failed to rule, then she improperly denied the complainant his opportunity to prove his case. She improperly allowed the agency to not articulate, a legitimate, non-discriminatory reason for its actions and denied the complainant his opportunity to contest it and prove reprisal/retaliation, harassment, and hostile work environment. You see how all the stuff the judge did wrong by simply chopping my complaint up? She put up half of the defense for the agency by chopping off the tail end of my complaint. It's horrible. It's horrible. I'll continue. The July 29th, 2020 order entering judgment says, complainant has satisfied the procedural prerequisites for a hearing, but because there are no genuine issues of material fact or credibility, the evidence does not warrant one. And that judge in that ruling, she cited C. Anderson versus Liberty, Celotex versus Catrix, Matsuida versus Zenith Radio Corps, and the March 2nd, 2020 decision does not dispute this. The record does not verify that she properly fulfilled her obligation to adhere to any of the legal principles, precedents, and requirements, but instead improperly simply gave the case away to the moving party without a specific explanation that could be appealed, contested, or responded to. Injustice will result if reconsideration is refused. By the way, this part right here, again, I didn't make up. That is, the movement demonstrates that some harm, legal or at least tangible, such as him not being able to prove his claims of reprisal, retaliation, harassment, hostile work environment. The agency will continue to violate Title VII with assurances that the EEOC will be so overloaded they will look the other way, and the complainants will not be able to rely on the integrity and compliance of the EEOC Appeals Commission. Would flow from a denial of reconsideration. C. Cobell and Bank Julius, quoting FBME Bank and Nuchin. Even if the appropriate legal standard does not indicate that. All right. So, just want to share to you the how difficult it is to proceed to get justice in EEOC case. You know, laws look great on paper, but the fact is, as you just heard, to do anything, to truncate your complaint, change it from one thing to another. They'll conceal evidence. They'll throw away your discovery emotions, and I'll share that in another one. But we can't stop fighting. You know, the system is incredibly broken, but it was more broken prior to today. Some people had to fight to get us here. We have to fight to take it to the next phase. Hopefully, at some point in time, our federal work environment will be a healthy, nurturing, encouraging place and the most powerful employment agency on the planet. Till then, we keep fighting. Don't quit. Reach out to us over on Facebook, get encouragement, and most of all, well, not most of all, but you have to study. You have to read these cases. Even if you have a lawyer, you have to read and be the lawyer's partner and to a degree, oversight. You have to interact and interface with your lawyer. But they treat you like a kid if you haven't done any studying, if you haven't done any preparation. And by the way, most lawyers, if you got the lawyer for the cheap, low cost retainer of $1,500 or somewhere around that, you can best bet that. And you can look at every case. It's even on the EEO site. There's every case. There's a line item for lawyer fees. Lawyer gets paid between $270 and $350 at the end of the case. By whom? Not you. By the agency. So if your lawyer is pushing you towards a agreement, a compromise, a negotiation that is not making you whole, you know why. They threaten to leave you if you don't accept the deal. You know why. They're not putting a full-throated fight forward for you. You know why. They're going to get paid at the end regardless by the agency. All right. Thank you so much.